You are stuck with me for 3 hours. Hope it's worth the price of admission. Uh, the past Supreme Court term um, was truly unprecedented. That phrase is often thrown around a bit too lightly, but I think it was actually warranted. In a single year, the court overturned Roe v. Wade, expanded the right to bear arms, reinvigorated a major doctrine used to limit federal power. There was an assassination attempt of a sitting justice. There was a leak of an entire draft opinion. And there was a presidential commission on reforming the Supreme Court, all in 1 year. Right? Usually that's enough for a decade. But this happened in the span of about 10 months, all during a global pandemic that never seems to end, and to boot a Supreme Court nomination where the person was confirmed before the predecessor was even retired yet. This was a remarkable year at the court. My goal for today is to walk you through last term, the 2021 term, and try to give you a preview of the 2022 term, which I think will be a little bit more quiet unless we get some election stuff, which Florida knows nothing about, right? So let's just take a step back to see how we got where we are now. From 1994 till 2005, the Supreme Court had no personnel changes. It's what's called a natural court. The same 9 members worked together for about 11 years. Justice Breyer was the junior justice for 11 years. Now, in the Supreme Court of the United States, the junior justice has a job. He runs the cafeteria committee. This is his job. It's sort of like a hazing ritual, if you will. He has another job. During the conference, only the 9 justices are there. The junior justice has to take notes and write down all the votes, how people vote. And if someone knocks on the door to make a delivery, it's the job of the junior justice to get up and answer the door. In fact, it's sort of a hazing ritual. If the junior justice doesn't get up, they just sit there in silence waiting. So you learn that lesson maybe once or twice. Do you have that in the Supreme Court of Florida, or no? You don't have that hazing ritual? No, maybe we should. Yeah, thank God. So Breyer was the junior justice forever, and this actually allowed this natural court with Chief Justice Rehnquist in charge to form. And people got a very good sense of where the court was. You had Justice O'Connor was sometimes a swing vote. You had Justice Kennedy was sometimes a swing vote. But for the most part, it was a leaning right 5-4 conservative court, unless you had certain hot button issues. Of course, the biggest case from that era was from this lovely state, which was the 2000 election decisions, and those went 5-4 to the right. But of course, George Bush would make 2 more appointments to the court. In 2005 and 6, Justices O'Connor and Rehnquist left the court. O'Connor by her own volition, Rehnquist not. And they were replaced by Chief Justice John Roberts and Justice Samuel Alito. The Roberts nomination didn't really, at least at that time, move the court too much to the right. It seemed to be similar to where Rehnquist was. But Samuel Alito was going to be far more conservative than was Sandra Day O'Connor. And this change was felt right away. There was a campaign finance case shortly after the switches called Citizens United, where it became very clear that Justice Alito was not on the same page as Justice O'Connor. There were cases involving affirmative action, abortion, where you see the O'Connor vote going one way and the Alito vote going other. So that was the first major change to get Sam Alito on the court. Then in 2008 and 2009, President Obama would have 2 picks back to back. Justice John Paul Stevens and Justice David Souter. They were replaced by Justice Sotomayor and Justice Kagan. Again, these picks didn't really shift the balance of the court. Souter and Stevens were fairly reliable progressives, as were Justices Sotomayor and Kagan. In some regards, the personalities are different. Sotomayor had background as a prosecutor, as a trial judge, so she brought a lot of good expertise to the court. Justice Kagan was a law professor and a dean, and she sort of was, very, very nerdy, and she brought some of that expertise to the court. But again, things stayed more or less the same. Then there were 7 years of stability. Justice Kagan was on the committee for the cafeteria for some time. Her biggest contribution to the court, actually, frozen yogurt. If you ever visit the U.S. Supreme Court, in the basement, there's a frozen yogurt machine. Thank Justice Kagan for that. Apparently, it's good, it's tasty, I've heard. But then in 2016, there was sudden change to the court. February of 2016, or after Valentine's Day, I remember it, Justice Scalia suddenly died. He was at a ranch in West Texas. The news sort of trickled out. And this was in the middle of the Republican nominating convention for the selection of the presidential nominee. That evening, there was a debate in Charleston, and President Trump came out and said, I'm going to pick Bill Pryor of Alabama or Dianne Sykes of Wisconsin, by the way, neither of whom made it to the court. But he put out names, and then Trump decided to put out a list of potential Supreme Court nominees. And this move, I think, helped him become elected. It assured at least many Republicans that he could be trusted on judges, which was the most important issue. President Obama nominated a judge named Merrick Garland. Yes, the current Attorney General was nominated to the U.S. Supreme Court. Guy never got a hearing, never got past go. The Republicans made the decision to stonewall the nominee and take no action on it. And they took a gamble. They took a risk that if they were able to hold out past the election, they can get someone more to their liking for Republican president. Of course, if the gamble went the other way and President Clinton or Hillary Clinton had won the presidency, we would have gotten someone perhaps to the left of Merrick Garland, right? So everything that happened last year stemmed from that one moment, right? If it was Merrick Garland in the court, there would be no Dobbs, right? There would be no Roe v. Wade overturn. The thing just would not have happened. Would not have been enough votes. The election happened. President Trump won the election, and less than a month later, Trump nominated Neil Gorsuch, a federal appellate judge from Denver, to fill the vacancy. Now, Gorsuch had clerked for Justice Kennedy and Justice White back in the early 1990s. Funny story, you know who his co-clerk was? Brett Kavanaugh. It's true, they were co-clerks together. They weren't really friends, though. Another fun fact, we all know that Brett Kavanaugh's high school, right? You know, went to the same high school as Kavanaugh? Gorsuch. They were 1 year apart in high school. Again, not really friends, it seems. And Gorsuch did not have any yearbook issues. He was a straight-laced kid, apparently. But Gorsuch and not Kavanaugh got the first pick in 2017. He was filibustered, which was, in hindsight, not a very prudent move because he was definitely qualified by any objective measure. But I think people were still upset about the way that Merrick Garland was treated. As a result, the Republicans, as they say, nuked the filibuster. They used the nuclear option, and they got Gorsuch through. Let me make this very clear. Had they not filibustered Gorsuch and got rid of the filibuster, Kavanaugh would have never gotten through, right? There's no way you could have nuked the filibuster for Kavanaugh. He barely had enough votes. So that was, again, the number of steps I had to get through to get to the point of where we are now just is just miraculous. Just a series of events, just one after the other. Just it's hard to quantify. All right. So Gorsuch just fits in. I think he's this kind of conservative, but he has this very strong libertarian streak on certain issues like criminal law, Indian law. He's idiosyncratic. The world's most interesting man. He's the most interesting justice. He never fits a mold, and I just can't figure him out quite yet. All right, fast forward to June of 2018. It was the last day of the Supreme Court term. I was actually in the building, and I walk into the court and say, Justice Kennedy's wife is sitting in the spectator section. There's Justice Kennedy's kids. Oh, and there are his grandkids. So that was my clue that the guy was going to retire. He didn't tell anyone in advance. He just went to the White House after the last day of the term to deliver a letter to the president. Now, there was a concerted effort to encourage him to retire, and not to say there was a deal, but the guys who are on the short list were Kennedy clerks. And indeed, the person to replace Justice Kennedy was his perhaps most prominent clerk, which was Brett Kavanaugh. Judge Kavanaugh was an appellate judge in D.C. probably one of the most well-known, well-regarded, just prolific judges. Almost all of his clerks went to the Supreme Court. Just and really a nice guy too. I got to know him really well. May not like me much anymore, but he's very friendly, and he's a very thoughtful guy, a devoted dad. Everything else aside, um, at the time, it looks like Kavanaugh's most contentious issues would be his record in the Bush White House. He served as the president's secretary. So every piece of paper the president gets went through Brett Kavanaugh. So George W. Bush's right-hand man for all those years. And the first hearing were all these silly fights about document production and privilege and things that no one really cares about. But then after the hearing concluded, the allegations of Christine Blasey Ford came forward. And this just ignited Washington. For a time, it looked like Kavanaugh might withdraw. He might resign when she agreed to testify. I'm sure many of you watched that hearing. Blasey Ford went up first. Kavanaugh went up second. There was a lot of yelling, a lot of screaming. Some apologies were thrown around. He didn't resign. He didn't withdraw. And he was confirmed by the skin of his teeth. He barely got through. Again, had the filibuster still been in effect, we would not have a Justice Kavanaugh. He would not be in office right now. Or he maybe still be in appellate court, but I think he would have to resign that also. So then the court was settled for about a year and a half. Go to September of 2020. We're about 6 weeks before the election. And Justice Ruth Bader Ginsburg passes away. Ginsburg passes away. Trump, as everyone expected he would do, he said, okay, we're not going to wait till after the election. We're going to do this now. Now. So she died 38 days before the election. Trump nominates Amy Coney Barrett from Indiana. She's a Seventh Circuit judge. She'd been a judge for, I don't know, about a year and change. Not much record to run on, but that's what he picked. Her committee vote was basically held October 22nd. She was confirmed October 26th, 8 days before the election. Now, in hindsight, we know that Trump didn't win. And had he not pushed her through, it's not clear who confirmed her after the election. Oh my God, everything that went on after the election, there's no way there would have been any opposition for this. So again, the number of sort of bank shots, right? The perfect lining up events to get to where we are today that's happened one after the other, it's hard to fathom. Any one of these things didn't happen. If Kavanaugh didn't get through, if Ginsburg had died like 2 weeks later, right, we would not be at this moment, right? And we have more change. Justice Breyer retired about 2 months ago, and he's replaced by Justice Katanji Brown Jackson, who was his former law clerk. So at this point, only one member is left from the Natural Court from 94 to 2005, and that's Justice Thomas. He's now the Senior Associate Justice. All right. So that's all the personnel changes. It takes a while to walk through, but it's very important to realize, had any of those things changed, had President Bush only gotten one pick, right? Had he picked not Sam Alito, but maybe Harriet Miers, right, another possible lawyer, where we are today would not have happened. All right. So I want to do now my roundup, and I did this a little bit differently. Sometimes people do it by topic. I like doing it chronologically. I want to walk you through October, November, December, January, February, March, April, May, June. Walk you through the year month by month, because it's a really fascinating narrative, a story of how this evolved. And I don't know, is there any way to tell people back there, stop making so much noise? There's a lot going on there. I don't know if there's any way. No, it's fine. Okay. If you can't hear it, it's fine. Okay. The worst is you ever speak and people have wrapped sandwiches. You ever have that? And they're all crinkling their sandwiches. I once told a group of law students, everyone, unwrap your sandwich now, go. It made my life easier. All right, so let's talk about October. October of 2021, we begin the term with an investiture for Justice Barrett. Because of COVID, they had never assembled in person. So they actually were in the building to do an investiture for Justice Barrett. But Justice Kavanaugh was not present because he had COVID. He was tested positive. Thankfully, he was fine. But very soon that evening, an emergency petition would come to the court for one of the first vaccine mandate cases. Yes, it seems almost like a thing of the past now, but last year was dominated by these cases about the vaccine mandates. A group of public school employees from New York urged them to block it because there was no exemption for religious freedom. Circuit Justice Sotomayor turned in the application by herself. This would be the first of many such cases from New York. October 4th of 2021 was the first Monday in October, right? These are the first oral arguments they've had in person since before COVID. When did you guys go back to in-person oral arguments? Earlier than October of 21? Good, that's good to hear. But Justice Kavanaugh was still out because he was still quarantining. The first case was Mississippi versus Tennessee. It sounds like an SEC football game. But it was actually a complicated groundwater case. It was a dispute over who would get the water. I will spare you the details. Tennessee won. But this is one of the earlier cases that was not too controversial. The second case involves abortion. No, not that abortion case. Another abortion case. Cameron versus EMW Women's Surgical Center. This is a case from Kentucky involving their Attorney General, Cameron. Kentucky passed a law that banned the so-called D&E, the dilation and evacuation method of abortion. Initially, there was a Republican governor who defended the law, but then the Democratic governor came into office, and he did not defend the law. His state health officer said, "We will not defend it." So the Republican Attorney General intervened to try to defend the law. The lower court said, "No, you can't intervene because your office had previously said we're not going to take care of it." This went to the Supreme Court. By an 8-1 vote, the Supreme Court reversed. The court said that you can intervene. This is an important issue when you have administrations flipping from Republican to Democrat, which may happen, who knows, right? Because a lot of litigation positions do switch. This allows the state attorney general the power to continue to defend a judgment below. Justice Alito wrote that it's important to allow states to defend their own laws in federal court. The only dissenter was Justice Sotomayor. She warned that the decision will make it easier for government officials to undo decisions made by their predecessors for political reasons. She's taken this position in a couple cases this term. Right, so that was the second case. Let's go to October 13th, the third case. So we go from the home of the Kentucky Derby to the home of the Boston Marathon. We're in the race here, right? This is the case of the United States against Tsarnaev. It's spelled Tsarnaev, Tsarnaev. The name should ring a bell. These were the two brothers who were responsible for the terrorist attack at the Boston Marathon in 2013. This was a tragic event. If you remember, they littered at the finish line area these homemade IEDs, improvised explosive devices. You take a crock pot or a pressure cooker and you fill it with shrapnel and explosives, and it wreaks havoc. This was a terrible event. Many people were killed. Many people were maimed and injured. Children were injured. I think another child was killed as well. After the event, the brothers went on a flee from justice. They ran away. They hijacked a car. They eventually were cornered in an area. This is the crazy part. One of the brothers actually drove over the other brother. So there were two brothers. One killed the other brother in the escape. So there was only one brother remaining. He was charged on many counts in federal court in Boston, including death by terrorist device and really gruesome charges. The jury sentenced him to death, which is a rarity in Massachusetts, because in Massachusetts they don't have the death penalty, but the federal jury sentenced the brother to death. But the First Circuit Court of Appeals, not the First Court of Appeals, the First Circuit Court of Appeals, in their wisdom, reversed. And they concluded there was error by the trial judge, right? The defendant wanted the judge to ask the jury specifically, what media coverage have you heard about the case? They asked the question, did you see any media about the case, which is a standard form in the jury, right? But they wanted a more precise question. What media coverage did they see, right? More specific. Is that reversible error? I don't know. There was also evidence that the brother who was on trial, I'm sorry, that the brother who had been murdered was involved in another triple homicide before the bombings. And the trial court said, not admissible. We're not going to admit allegations of a crime against the deceased brother. So there were a couple grounds for appeal, and the First Circuit held that the trial was invalid and ordered a new trial to be held. And again, trying to pick a jury in Boston where this marathon bombing ripped through the community, I think must have been hard. The voir dire for that case must have been very difficult. So I respect the judge. This went to the Supreme Court, reversed 6-3. This was one of the first 6-3 opinions we have. The court's conservatives were the majority, and the court's progressives were in dissent. Justice Thomas wrote the majority opinion, and Justice Thomas said, the trial judge, good enough for us, right? May not have been perfect, but that's not the standard. The Sixth Amendment does not require that jurors know nothing about the case. The standard is one of prejudice or perhaps bias. There was no evidence in this case. Justice Thomas wrote that Tsarnaev committed, quote, heinous crimes. The Sixth Amendment guarantees him a fair trial for an impartial jury. He received one. Done. Justice Breyer is from Boston. He knows the area very well. In fact, he's now a professor at Harvard, so he's back in his home ground. Justice Breyer wrote the dissent for Justices Kagan and Sotomayor. He said there was evidence that was critically important for Tsarnaev's defense, right? If his brother had been involved in murders, that should have been admissible at least for purposes of sentencing, for purpose of mitigation. I mean, I don't know what jury in the right mind could have not put this guy to the death penalty, but what do I know? So now the case goes back. It's actually a tough issue because the Biden administration has opposed the death penalty. And it's not entirely clear what they will do because they're sort of at odds with their own position if they'll pursue it. So I think what they'll do is they will seek to finalize the conviction, but then not actually perform the execution or something like that. So it's sort of this weird dance that is politics, not my thing. October 17th of 2021, the Supreme Court Commission. Remember that? That was a big deal last year, right? During the election, President or candidate Biden was being peppered with questions at the Supreme Court. What are you going to do? What are you going to do? Will you expand the court? And Biden was a law professor at Widener University in Delaware. He had served as the chair of the Judiciary Committee. He just never really seemed interested in court reform or court expansion, whatever you want to call it. So after he came to office, he did what all executives do to kill ideas. He appointed a commission, right? That's what you do. When you want an idea to die, people are smiling, they know this works. The governor appoints a commission, the president appoints a blue ribbon commission. This had about 60 members. Imagine a commission with 60 members meeting all over Zoom. I can't even fathom that. It's basically everyone in this room, I think, would be on a commission, and you have to reach unanimity on something of gravity like the Supreme Court. There were law professors, there were some advocates, there were appellate attorneys. Politically, it skewed left, but there were some conservatives, so there was at least an attempt at balance, which we acknowledge. They met on October 17th publicly as the court's term was beginning, and they released a 200-page report. I will admit I did not read all of it, but I read parts of it, so I can at least report on that. And there were a couple of ideas, right? One would be court expansion, that is adding new seats to the court. We've been at 9 now for over 150 years. The number one is high as 10, it's been as low as 5. The Constitution's silent. The Constitution doesn't say the size of the court. It's up to Congress to decide, I think at least. The committee was divided about adding justices. Divided, which means there was actually a plurality saying that we need to go to 11 or 13 or 15 or 17, whatever the number happens to be. But the report said the risks of court expansion are considerable. Of course, once you start expanding the court for a Democratic president, there's nothing to stop a Republican president from expanding the court. So you go from 9 to 11, 13 to 17 to 25, then you have a 65-member Supreme Court, and then you have panels and another court of appeals, right? There was more support for the idea of term limits. The U.S. Supreme Court basically guarantees position during good behavior. which is life tenure. There is no mandatory retirement age, so justices routinely serve into their 80s and maybe even 90s. We've had several justices die in office, right? Justice Ginsburg, Justice Scalia, Chief Justice Rehnquist. We've had other justices who were forced to resign on very short notice due to health, Justice Brennan, Justice Marshall, and others. Justice Breyer is one of the few people who just retires on his own. It's like, all right, I'm healthy, ready to go. Justice Souter was also like that. But the idea of term limits would be to sort of ensure you don't stick around forever. And if you sort of stagger the term limits, every president would get two Supreme Court nominations in a 4-year term if you sort of stagger them. Of course, the difficulty of term limits is how do you do it? There were some people in this committee who thought you needed a statute to do it. I think you need a constitutional amendment to do it. I don't think you can modify the Supreme Court's jurisdiction, tenure protections without an amendment to Article 3. What do I know? So they released this massive report, which was supposed to be sent to the president. They couldn't make recommendations, which is kind of weird, right? You have this blue ribbon committee that can't actually recommend anything. So what were they there for? To write a report. That's what they do. The evening after this report's released, a reporter asked President Biden, "Do you support term limits?" His response, one word, no. So he shot down his own committee before they even put their damn thing out, right? It's remarkable. Any other time, a presidential commission on Supreme Court reform would be a huge deal. This year, it barely got any oxygen. All right, so that was October 17th of 2021. The next day, abortion comes to the Supreme Court. No, still not that case. This case is from Texas. Texas, where I live, enacted a law called SB 8, Senate Bill 8. This is often called the fetal heartbeat law, which is now sort of spread across the country. It bans abortion at the 6-week mark when cardiac activity can be detected. But SB 8 is unique. It's not enforced by the state. It's not enforced by the Attorney General. It's enforced through private litigation. That is, civil suits, almost like a quitam if you want to use the analogy. Why was this law enacted? Very candidly, to evade judicial review, right? To evade pre-enforcement challenges. There's no doubt why this was enacted. Had this law been enforced by the Attorney General, the state would have been sued in 5 seconds, preliminary injunction, done. But by creating private enforcement action, who are you going to sue, right? Who is there to sue? The law says the Attorney General cannot enforce this law. So he's not a proper party, right? He has no role to enforce. So the plaintiffs in this case, they got creative. They sued the trial judges in the state, and they sued the clerks of court. Huh? You all have clerks in your court? What is the job of a clerk? A clerk accepts filings, right? I mean, it seems like a ministerial task, but someone goes to the court, either paper or electronic, says, here, I have a complaint to file, right? The clerk takes the thing, puts some markings on it, dockets it, scans it maybe, and says, okay, now you have a civil case. So they said, aha, if we can enjoin the clerks, they can't even accept a complaint. And if they can't accept a complaint, there's no litigation, right? There's no law. And they also tried to enjoin the state trial judges. That if a state trial judge can't even rule on a motion or can't even rule on a complaint, the law has no effect. I don't know how you think about. I don't know, guys, how you feel about suing judges and clerks. It's a weird. Usually, you guys have immunity, right? You know about this. I'm sure that you learned this the first day of judge school. You guys, you're immune. Judicial immunity is a good thing, right? Because if a litigant doesn't like what you do, too bad, you can't sue me, right? And generally, your staff are covered by that immunity. I mean, can you imagine suing the clerks of court to say you can't accept a complaint? I mean, just pause for a minute. Are clerks equipped to read complaints and say, aha, on paragraph 52, I can't do it, right? Are they really going to scrutinize every paragraph of a complaint? I mean, what happens if there's one complaint that's good, one complaint that's bad? Do they docket part of the complaint? How does it affect jurisdiction? Anyway, so this was always a sort of last ditch effort to try and stop the law because they had no other options. The trial court in Austin, Texas said, yes, you can sue the judges and the clerks. The Fifth Circuit vacated the injunction. Now, there was another case brought by the United States. The United States sued Texas. They sued the state, right? I can't sue Texas because of sovereign immunity, right, with the 11th Amendment. But the United States is not bound by that rule. So they sued Texas, which includes everything in Texas, every judge, every clerk, everything. I mean, technically, I don't know if he's facetious, they sued me also, because as a citizen of Texas, I could have brought one of these lawsuits. So I was a defendant nominally, at least in the suit. This case goes to the Supreme Court on October 18th. The court does not grant any sort of emergency relief. They allow the law to remain in effect. They did not rule on the so-called shadow docket. Now, did you hear about the shadow docket? You heard about this? I'm so annoyed with this shadow docket. Let's go with the emergency docket, right? Every court in the world has an emergency docket. I'm sure all of your courts have it. Death penalty, right? There's some times when courts have to act in a very fast manner, right? You need to, just by the nature of the case. And the courts long had an emergency docket. Some cases have to resolve quickly. You can't take 18 months to sit on. The idea of the shadow docket was born by a professor named Will Bode. Will's a professor at Chicago. And he described that there are lots of orders from the court that aren't getting attention. They're sort of on the sidelines, in the shadows, right? Not in this sort of nefarious, evil sense, but that's just where the court decides it without oral argument. And over the last 7 years or so, the number of shadow docket cases has skyrocketed. It's a confluence, I think, of Trump, COVID, and a more conservative court that's sort of out of step with the lower court judiciary. There are a lot of factors for it. None of it's nefarious. So I think a lot of these, there's a new book out saying that, the shadow docket's a threat to the republic. Give me a break, right? It's just give me a break. But the court did not decide this case, the fetal heartbeat law, on the shadow docket. Instead, they used what I've been calling the rocket docket, which will they decide cases real quick. And we know they can do that. I hate going back to it, but how many days was Bush v. Gore? Like 2 weeks from start to finish? They run that one pretty quick when they have to. Doesn't always produce the best work. Sometimes there are errors and glitches, but when they need to move quickly, they move quickly. So they moved the abortion case onto the rocket docket, and they said oral argument read 10 days later. When they want to move quickly, they can move quickly. So let's go ahead to about 10 days later, a case called Dovey Mills. This is a appeal from Maine. Maine required their public employees and healthcare workers to become vaccinated, and there was no religious exemption. There were exemptions if you had disability or some sort of health concern, but not based on religious concerns. It goes to the Supreme Court. This court split 6-3. Justice Thomas, Alito, and Gorsuch would grant relief to the workers. Justices Roberts, Barrett, and Kavanaugh would not have granted relief. And this reflects what I've often called the 3-3-3 split on the court. It's a 6-3 conservative court, but very often the three, Alito, Thomas, Gorsuch, are a lot more conservative than the other three. And they often fracture in these sort of COVID-related cases. And Justice Barrett had given some remarks saying, we're not partisan hacks. Just trust us. We know what we're doing. And it seemed that Barrett was getting a little bit iffy on the emergency docket. And then Barrett wrote this opinion, one of the few opinions she actually wrote this year by herself, right? Where she said that people are now using the emergency docket to force the court to the merits preview. And she said we should not be deciding these cases on a short fuse, but the benefit of full briefing. So here Barrett signaled, no more shadow docket for me, go away and leave me alone, except for a couple of cases where she grants relief. But at least here, she's signaling that I'm not giving shadow docket relief. So again, all these books about the shadow docket, I think it was a blip. It's over. Barrett's signaled she's not interested. All right. So let's go to November 1st of 2021. We have the SB8 oral arguments, the fetal heartbeat case. I listened to those arguments live, And, it seemed like Texas was going to lose. Justices Kavanaugh and Barrett seemed like they were not happy with the Texas law, that it sort of cuts off this pre-enforcement review, and that they were going to allow a suit to proceed against the clerks of the court. So again, all of your clerks would be subject to lawsuits, which is something novel. After this happened, I had a lot to say about it, as did others, and we'll see, it didn't quite turn out that way. All right. 2 days later, New York State Rifle and Pistol Association versus Bruin, the big Second Amendment case. So some background first. Before 2008, the Second Amendment really had no meaning in federal law. It had been considered a dead letter. But then we have District of Columbia versus Heller. DC v. Heller recognized the Second Amendment protects an individual right to bear arms, a right that's not connected to militia service. This was a 5-4 decision, a huge case, a landmark case that said the Second Amendment is something you should all care about. But there was this paragraph in Heller that said, we're not deciding all the cases about the Second Amendment, right? We are not casting doubt on long-standing prohibitions on felons and others possessing arms. We are not casting doubt on bans on possessing arms in sensitive places. And by the way, we're not going to set a tier of scrutiny. It's not rational basis, but we're not going to say what it is. And we'll come back to this later. Right? So Heller was this massive decision that said there's a right to keep a gun in your house and said nothing else. And they left open all these other issues. 2 years later, we have McDonald v. City of Chicago. This case incorporates the Second Amendment, holds the Second Amendment limits state power, but nothing new about what the Second Amendment means. So at this point, okay, we have this new right. What does it mean? Are we using strict scrutiny? Are we using intermediate scrutiny? Right? Is this a fundamental right or a non-fundamental right? What role does history play? What about bans on so-called assault weapons? What about a right to carry? What about high-capacity magazines? What about non-violent felons can have their gun rights restored? So again, that was 2010, and I thought, okay, maybe the Supreme Court will take a year or two and take another gun case. Nope. 2010, no cases. 2011, no new cases. 2012, no new cases. 13, 14, 15, 16, 17, 18, 19, 20. Almost a decade passes before they even take another gun case. And during this time, the lower courts mostly settled on intermediate scrutiny, a very quasi-deferential framework which means the government wins, right? That's what it usually means. Almost every gun case came out in favor of the government, without fail. And finally, the court takes a case from New York. New York had this weird law that said if you wanted to bring your gun to a shooting range, you could only use a shooting range in the city of New York. You couldn't go to New Jersey, for example. And you're going to be locked in a case. Right? So even if you had a gun permit, you couldn't transport your gun to a permit outside the city. By the way, most people in New York City don't have cars, so putting a gun in a locked trunk isn't always an option for people. All right, so what happens? The Supreme Court grants review on this case. What does New York do? They defend their law? No, they do not defend their law. They repeal it. Not only did they repeal the law, the state legislature passes a statute preventing them from reenacting the law. This is how you moot a case. You basically salt the earth and you say, we will never ever do this again. I promise, pinky swear, right? We promise, promise, promise. So the law was repealed and the Supreme Court dismissed the case as being moot. Look, they were trying to mess with the court's jurisdiction, right? The court granted a case review and they were trying to take the case away. And they succeeded. But right after that case, you have another challenge to New York's carry law. New York had, past tense, New York had what's called a may issue regime, right? Florida, Texas, and others are shall issue regimes, which means if you apply for a gun permit and you pass the background check, you get your permit. Actually, we have constitutional carry now, so we don't have to apply for a permit anymore. But in theory, we had shall issue. New York was may issue. Even if you passed the background check, You still have to show cause, a special justification of why you needed a gun. Merely saying self-defense was not enough, right? To have some special justification of why you needed a gun. If you were a politician or a celebrity or you're friends with the sheriff, you're good, right? You can get your permit. But if you're a regular law-abiding citizen, good luck. You're not getting anything. The Bruin case was argued November 3rd. The arguments were wide and expansive, talking about the nature of the right to bear arms going back, 700 years to the 1300s. What were the laws of carrying in medieval times in the Wild West? What about the relevance of the Sullivan Laws, right? New York's laws were passed in the early 1900s, and there's not much of a secret about this history. They were designed to take guns away from Irish and Italian immigrants. This is the purpose of these laws. There were questions about where would you be able to carry? Is the subway a sensitive place? Would Yankee Stadium be a sensitive place you could ban guns? What about the campus of New York University? Does anyone even have a campus? Have you ever been there? I don't think it does. He's laughing. That's it, right? It's Greenwich Village. There's no campus, right? Is the entire island of Manhattan Island, which is it's actually not an island, it's a peninsula because it's connected by the anyway. Is Manhattan Island a sensitive place? Can you ban guns within 100 feet of a school? Is there anywhere in Manhattan that's not within 100 feet of a school, right? So you have all these questions, and the court looked like it was going to rule against New York, but we'll get to that later. I want to save this case for June because it was 1 week later we get the death penalty. But this is a case that combines the death penalty and religious freedom. Ramirez versus Collier. So Ramirez was a convicted murderer. He murdered a man in cold blood. He stole from him a few dollars. It was a really tragic offense. But during his time in prison, he found God, and he became very close to a minister who would come to the prison to preach. And in his faith tradition, when a person is dying, the preacher should lay hands on him. All right, and this phrase "lay hands" means different things to different people. Some people's like, you put the palms of your hands, like different things, right? But this minister said, all I need to do is have my finger, even a single finger, on the man's body during his last moments, right, to say the last rites for him. And he said, I can even touch his foot, his ankle, and that would be sufficient. Now, the state of Texas objected for a number of reasons. One, at the time, they only allowed official chaplains into the execution chamber, right? People have been vetted by the state. Now, I've actually never been in the execution chamber. Maybe you have. I understand these are very small, crowded areas. There's a lot going on. They're administering the injection. They're administering the protocol. They have doctors. And there's just not space to have a lot of people sort of floating around. Also, there's a lot of need for communication. If someone's singing their praise God, if someone's preaching while they're going on, might be distractions. So State of Texas said, no, if you want someone to lay hands, you can use our official chaplain, but we can't use your preferred person during this proceeding. He can come in before the execution, not afterwards. Right? This case was brought under RLUIPA, my favorite acronym, the Religious Land Use and Institutionalized Persons Act, which is basically religious freedom for prisoners. Again, this came to the court on the emergency docket, but the court puts it on the shadow docket. They schedule oral argument. This, I think, is a new trend. I think in response to all this criticism of the shadow docket, they say, fine, you want argument? We'll give you argument. It'll be in 2 months, right? It'll be in 1 month. It'll be in 6 weeks. So they're putting very super duper expedited oral arguments up quickly. And then the case took 4 months to decide. So it wasn't that simple. So they had the arguments right away, and they sat on it. The vote here was 8-1. Chief Justice Roberts wrote the majority, and only Justice Thomas was in dissent. And the court ruled in favor of the prisoner. And they said the state was required to allow the preacher to lay hands on the prisoner during the execution. And they said, we acknowledge the concerns, but if he just sort of stands to the side and touches his leg, right, that would be sufficient. Um, Justice Thomas dissented, and his dissent was kind of cynical. They often are. And he said, this is just an attempt to delay his execution. This is not really about religious freedom. And I think on the record, he's probably right. This claim was only raised fairly late. There's a lot of forfeiture. A lot of these issues were waived. And it wasn't clear that he wanted the minister to touch him until after the litigation went on. But then again, prisoners often, are not always the cleanest cases. Um, After this went back to the lower court, the trial judge or the trial prosecutor said, "I'm not going to seek an execution anymore." So now this case is still floating around. So if delay was at hand, delay was had. All right, so now we get to December 1st of 2021. And this is the case we all came here from. We came for a lot of reasons, but this is the case we were all interested in, which is Dobbs versus Jackson Women's Health Organization. This is the biggie. This is probably the most significant Supreme Court case in half a century. Um, it's just hard to overstate how important this is. So let's just take a brief walk through history, if we can, a little stroll through memory lane. The 14th Amendment of the Constitution has a due process clause. It says that the states cannot deprive a person of life, liberty, or property without due process of law. What does this word liberty mean? Does it have meaning or substance, right? This concept became known as substantive due process, the idea that the due process clause isn't just about procedures, like you have a trial with a jury and fairness. It's about protecting fundamental substantive rights. And so during the early 20th century, the right to contract and so-called Lochner era was very in vogue. And then starting in the 1960s, the court began to say, well, we're looking a little differently. There's maybe a right of privacy, right, in the Constitution. In Griswold versus Connecticut, the court found this right to access birth control for married couples. And then later, the court said even unmarried couples can get birth control. But the biggie, right, the big landmark case came in 1973, which was Roe v. Wade. Roe, who was Roe? Her name was Norma Mccorvey. She was a woman in Texas. She had actually had 2 children before, which she'd given for adoption, and she became pregnant a 3rd time. She had told people she was raped because she thought that would get her an abortion at the time. It actually would not have. In fact, she made up the allegations as well. But she did find these 2 lawyers. She just wanted an abortion. She didn't want to be a litigant, but they sort of pressured her into the case. She later talked about how she regretted that move. Went to the Supreme Court. The Supreme Court said that the Constitution protects a right to abortion. The exact basis of the opinion was never entirely clear. They said maybe it's the 14th Amendment, maybe it's the 9th Amendment. We don't really know. We don't have to say. But the Constitution protects the right of abortion. And the court creates this trimester framework, which you might recall, that during the first trimester, basically no abortion restrictions were allowed. During the second trimester, there might be some restrictions for the mother's health. And the third trimester, you can actually prohibit it, but not really, because the concept of health was expanded to include mental health, and that could basically provide a out at every month of the pregnancy. So the Roe decision created sort of this neat trimester framework that was in effect for about 20 years. Roe proved very unpopular. It galvanized the evangelical movement in the United States. It led, I think, in part to President Reagan's election and selection of 3 justices to the Supreme Court. Fast forward to 1991 with Planned Parenthood versus Casey. At the time, there were 8 Republican justices in the Supreme Court. 8, right? Kind of like the Chris Florida Supreme Court. Sorry. Sorry. But it was overwhelmingly Republican appointed. Yet, by a 5-4 vote, the court upheld Roe. 2 of Reagan's appointees and 1 of George H.W. Bush's appointees cast the deciding votes in Casey. It was Justices O'Connor Kennedy, and Souter, right? They wrote the joint opinion in Casey. Now, they didn't reaffirm Roe in its entirety. They sort of got rid of the trimester framework, but they replaced it with the so-called undue burden test, which is sort of like strict scrutiny, but not exactly. That before the point of viability, the government cannot impose an undue burden on abortion, right? That was the standard. Justice Scalia wrote this bitter dissent in which he compared Roe to the Dred Scott decision as this sort of abuse of judicial power. Chief Justice Rehnquist warned that when you start looking to public opinion and moderating your decisions to try to avoid controversy, you fall into a bottomless pit. And Rehnquist and Scalia warned that Roe would not belong to the world. But to most conservatives, this seemed like this massive defeat. You had this 30-year movement to try and get conservatives on the court, and they go around and they reaffirm Roe. Post Casey, the effort became much more focused. And the effort became to appoint judges who would be willing to overrule Roe, but more importantly, who would not be afraid of the consequences for doing so. And this is largely the story of what happened 30 years after Roe, right? The story I told you, we did not get Harriet Miers, right? We got Samuel Alito, right? The Republicans did not confirm Merrick Garland. They held the seat open to get Neil Gorsuch. The Republicans did not cut and run with Brett Kavanaugh. They pushed him through because they realized they need to fight for this. And Trump didn't let the Ginsburg seat stay open until after the election. They put on Barrett. All of those sort of brash moves were done with Casey in mind. That when you let down and you put through judges perhaps aren't your first picks, you get Casey. So really the Casey decision, even more than Roe, led us to where the current moment was with Dobbs, right? Mississippi enacted the 15-week abortion ban, which was facially unconstitutional, right? You can't ban abortion in 15 weeks. There's no viability in 15 weeks. I don't care what neonatal tech you have. I don't care what technology you have. 15 weeks, there's no viability. The fetus cannot survive outside the womb. Some people say 23 weeks, 24 weeks, 26 weeks. It depends who you ask, right? But it's in the 20s, ain't 15. All right. So that was the Dobbs case, and the court would argue it in December. Mississippi came to the Supreme Court asking to overrule the Roe decision. They didn't have to do that. They made a conscious decision to say overrule it. They could have taken a more moderate approach. They could have said, well, Your Honor, maybe overrule a more recent case, Whole Woman's Health versus Hellerstedt, right? Maybe take a more incremental approach. But the AG and their Solicitor General decided to go all in, right? I'm going to come back to the Dobbs case later because I want to discuss in the context of the leak. But it was a significant decision to go all, put all of your chips in, right? To say overrule everything because it could have backfired. It almost did. December 8th, 2021, another argument. Carson versus Macon. This is a case involving religion and education. We have in the First Amendment 2 religion clauses. You have a free exercise clause and an establishment clause. And they've often been viewed as being in tension. Where we provide too much protection for religion, right, you're actually kind of establishing religion, right? There's too much intermingling, if you will, between the church and the state. But if you treat religion too unfavorably, we're not giving anything to religion, we're not giving you guys anything, well, then you might have a free exercise problem, right? That you're burdening their free exercise of religion. So in the last 20 years, the court has sort of said there's what they call playing the joints, J-O-I, joints, like you kind of squeeze things around. That if you're worried about violating the establishment clause, just don't give any special benefits to religion and you'll be fine. That was the rule in the Rehnquist court, but that rule has been under attack in recent years in several cases. One was called Trinity Lutheran versus Comer from Missouri. Missouri would give these, at playgrounds have these rubber chips that the kids fall on, they don't break their knees. Yeah, these are good things. So the state would hand out these rubber chips to various playgrounds. The kids don't hurt themselves. A playground that was attached to a religious school, the Lutheran school, applied for the chips. And the court said, no, we cannot give you these chips because you're religious. Go away. Slightly exaggerating, but that was the gist of the case, right? They were qualified. They didn't get it. All right. Went to the Supreme Court. The Supreme Court said, no, you cannot do that. You cannot discriminate on the basis of religious status. That was the key word, religious status. They said the rubber chips are used in a playground. That's not a religious activity. So give them the chips. There was dissent. The dissent said, wait a minute, though. By giving these chips to the playground, you're making school more attractive to people in the community, and you're actually helping the religion. That was the dissenting view. Breyer and Kagan were in the majority there. A couple years later, you have Espinoza. In Montana, the state would give certain tax credits to parents to go spend go spend at various religious schools. But the state did not give any credits to religious schools. Court said, no, you can't do that. This is discrimination on the basis of religious status. Again, there's a status use distinction. It wasn't being used for religious funds. But then we get to Carson versus Macon. Maine is an unusual state. It's very rural. There are many areas with no public schools. And what the government does is they basically give you money to spend it at a private school. You can't spend it at a religious school. All right? So now you have religious use, right? These are money being spent at Catholic schools and other religious schools in the state. And this case goes to the Supreme Court. It seemed very obvious that the court was going to rule in favor of the schools. We didn't know how. Justice Kavanaugh said in arguments, this is discrimination on the basis of religion. Straight up. All right, I want to come back to this case a little bit later. All right, December 10th, we get a ruling in the fetal heartbeat case. Not what we expected. So remember there was a case brought by the United States. They sued the entire state of Texas. The court dismissed that case as improvidently granted, meaning this is too hard, we don't want to mess things up, right? It's not clear there's a cause of action that allows the United States to sue a state. There's some cases involving equity where the United States can sue over labor strikes, but this is not clear. But then by a 5-4 vote, the court rules that the clerks and the judges cannot be sued, right? These are judicial officers, right? Their job is just to process paperwork, the clerks. They're not people who are designed to enforce laws. And judges, you guys have immunity, right? You're not there to decide a case in favor of one side. You're there to be neutral judges. The idea that a judge enforces the law is kind of numb, right? You are all judges. You're here to do your jobs. You're not enforcement agents. Chief Justice Roberts dissented. He will allow the suit against the clerks. Now, Justice Thomas, as he often does, concurs and says, well, I agree with the majority, but no one can sue under this law, right? The majority said, well, there might be some licensing officials who, license doctors. Maybe you can sue them. And Tom's like, no, you can't sue them. And oh, by the way, where's Judge Sutton? This is a question of state law. And we as the Supreme Court should not be deciding how best to read a Texas statute. So Thomas actually says his opinion, you know what? Fifth Circuit, you guys should certify this to the Texas Supreme Court and just check on this issue. Can these licensing officials enforce it? And you know what happened? Fifth Circuit certified it. And you know what our Supreme Court said? Nope. The state licensing officials cannot be sued. So the Texas Supreme Court basically overruled the U.S. Supreme Court. It can happen. It can happen. The Texas Supreme Court said, hey, Gorsuch, you were wrong. That's nice. And they did it in a very gentle way. It's like, well, the Supreme Court said this, but here's what we're saying. Judge Sutton was right? The Texas Supreme Court is the final arbiter over our state law. There was a vigorous dissent from Justice Sotomayor. And she said the clear purpose and effect of SB 8 is to nullify this court's rulings. Okay? But keep in mind, by the time this case was decided, Dobbs, the abortion case, was already internally conferenced. The justices knew there were already going to be 5 votes over Roe v. Wade. So they may have thought, well, Roe v. Wade's going to be gone in a few months. Let's not make a mess with this Texas situation. So I think that definitely had an effect. They knew Roe was going away. And who cares about fetal heartbeat laws at this point, right? Because it'll be surviving under the constitutional standard. All right. So now we go from abortion to COVID. So think back to December of 2021. Remember Omicron? Does anyone even remember this, right? This was this variant that was raging. Masks were everywhere. And states were imposing vaccine mandates. Not this state, I don't think. In my own state as well, there were no mandates imposed. But the federal government jumps into the fray. And the Biden administration enacted two series of regulations I want to talk about. There are two different kinds. The first was the OSHA mandate. This is the Occupational Safety Health Administration, right? OSHA. OSHA said that if you are an employer, you must require either vaccination or testing, regular testing, as a means to promote workplace safety, right? That COVID poses a threat to the workplace, and you need to have these requirements. The second policy was through CMS, which is the Center for Medicaid and Medicare Services. I don't know why it's CMMS, but it's just called CMS. If you participate in a Medicaid or Medicare program, you must be fully vaccinated. Okay? So these are mostly healthcare workers. This is litigated, and a circuit split forms. The Fifth Circuit said that the OSHA mandate was unlawful, and the Sixth Circuit said the OSHA mandate's fine. Again, this case goes to the Supreme Court, and we go put it on the rocket docket. Again, they rocket through these cases. Okay, this brings us to the end of the year. One of my favorite things to do on New Year's Eve every year is to read the Chief Justice's message. I know you all do the same thing, right? No, you don't. No, it's every year on 6 p.m. The message comes out from the chief, where he gives sort of just like a state of the judiciary address. Roberts is a good writer. He drives me nuts sometimes, but he's a very good writer. He was one of the best lawyers in the world in private practice, but the guy can write. And what I love about these, this is Roberts unfiltered. This is not Roberts trying to be, you know, this crafty judge, or Roberts trying to keep 5 votes. He's just writing. And if you ever want to read good writing, just pull this up. It's a very good report. And the theme of his report was independence of the judiciary. And if you read this very carefully, Robert's saying, I know there's lots of criticism of the court, but don't worry. We have this under control. Don't call us. We'll call you. This was a response to the court the court reform agenda. Like, we'll take care of it. So Roberts is basically telling everyone, back off. This is my show. At least for a while. 1 week later, the vaccine mandate case has come out, and the court splits the difference. The court says that CMS, the medical agencies, can require the vaccine requirement, but OSHA, that is private employers, cannot be forced to require vaccine or testing. And the basis of this ruling, I think, is in keeping with the Roberts Court approach. There is no clear statutory authorization for a vaccine or testing requirement. There is just general provisions about protecting public health. And what the court's saying is, if you want to take such a bold, sweeping action, there must be a clear statement to the effect, right? There are these major questions. That's the theme we talk about today, the major question doctrine. For these major questions, there must be a direct authorization to take this action. And the court said COVID's a risk everywhere, right? It's not a specific risk by virtue of being at work. COVID spreads everywhere that people gather. If we give OSHA the power to regulate every facet of our daily life, simply because most Americans have jobs and face the same risk while on the clock, the federal government's power goes everywhere. Justice Breyer, Sotomayor, and Kagan dissented, and they said this stymies the federal government's power to protect us from this unprecedented threat. Right. So the CMS rule was upheld, but the OSHA rule was struck down. As a result, there's never been a national vaccine mandate. And in hindsight, we know now that the mandate itself without the booster hasn't proved to be very effective. So I think this issue is sort of just pettered out and will just sort of vanish and stay in the U.S. reports nowhere else. All right. January 18th of 2022, Shirley v. City of Boston, another Boston case. If you ever go to Boston, there's a city hall with these flagpoles, these huge flagpoles. And the city allows anyone to just bring a flag if they register and say, okay, we'll raise your flag up. Flag representing different countries, different groups, different schools. They accepted every flag that was brought to them until a Christian group brought a flag with a cross on it. And they said, oh, no, we can't do that, right? We can't do that. That raising a cross on a flag would violate the Establishment Clause. The group brought a suit arguing this violates their free speech rights. The First Circuit in Boston upheld it, and the Supreme Court reverses by a 9-0 vote. When you get reversed 9-0, that's gotta hurt just a little bit. Just like, ouch, right? They all agree. And Justice Breyer wrote the majority opinion. And the court basically said, in classic Breyer factor, this is a holistic inquiry, as he always says this. We look at lots of factors, right? I'm going to miss Justice Breyer. I really will. His balancing tests were always fun. They're hard to teach, but he's really trying to get it right. I will miss him a lot. And what Breyer said was, we need to look at, when you see these flags being raised, is this going to be viewed as a message from the city or a message from a private citizen? And because they raised every flag in the world, this was considered a private message. There was some debate about whether this was government speech or public speech, but the Breyer opinion allowed it to go forward. All right, January 19th, we get the leak from the Supreme Court. Everyone looks up. No, not that one. We get a different leak. This is a scandal I called Maskgate. Maskgate. On the court, Justice Sotomayor is diabetic, and she consistently wears a mask in public events due to her being immunocompromised. The other justices did not wear masks, and in fact, if you look on the bench, Justices Gorsuch and Sotomayor sit next to each other. And there was at least one case where Sotomayor didn't come to the court. And people are rumoring, oh, maybe she doesn't want to sit next to Gorsuch because he's not wearing a mask. So NPR puts out a report saying that according to our sources, by the way, when you hear about sources, I know you had a speaker the other day, I'm just really skeptical. People have access to grind. People always say they know things they don't know, so I'm just always skeptical about these people have sources. I have no sources. No one talks to me. I don't want to talk to anyone. But look, when you have sources, you have to be very cagey because you don't want to trespass. I say whatever the heck I want, right? But NPR, Nina Totenberg, says, we have a source close to the court who says that Sotomayor will not sit near Gorsuch because of refusal to wear a mask. And a statement from NPR saying that Chief Justice Roberts asked the justices to mask up, and they didn't. Ooh, scandal, right? See, it'd be great if these sources were accurate, but they're not. It's all made up. I'm sorry, it's nonsense. Sotomayor and Gorsuch put out a joint statement. This never happens, folks. A joint statement saying, this reporting surprised us. It is false. Capital F-A-L-S-E, false. While we sometimes disagree, we are warm friends and colleagues. Isn't that nice? So again, these sources are not sources. I don't know what they are, right? And then later, Chief Justice Roberts had a statement saying, quote, I did not request Justice Gorsuch or any other justice to wear a mask on the bench. Okay? NPR stood by their reporting. So again, I know you have lovely speakers. I just take this up with a grain of salt. There's an old expression, those who know don't talk, and those who talk don't know. I'll leave it there. A couple days later, June 26th, Justice Breyer announced his retirement. But actually, it's funny, he wasn't ready yet. NBC scooped him, right? He was going to take his time, but NBC, the sources, right, were right this time. NBC said, Breyer's going to retire. And the next day, Breyer went to the White House. And he said, I have been aware of the great honor of participating as a judge in the effort to maintain our Constitution and the rule of law. He's such a nice guy. I like him very much. We're going to miss him in ways we don't even appreciate. President Biden made an announcement saying the person I pick will be the first black woman ever nominated to the court. So he basically indicated the range of people he was going to select. Now, when would Breyer actually retire? He didn't say I'll retire on a certain date. He didn't say I'll retire when the term ends. He said, I intend this decision to take effect when the court rises for its recess, assuming by then my successor has been confirmed. So he didn't actually announce his retirement. Sort of this conditional statement, which he could have withdrawn. He wasn't going to. It was a very Breyer-esque statement. All right, February 2022. This is a case called Arizona versus San Francisco. It's not a football game. This involves the public charge rule. President Trump tried to enact a rule that would make immigrants who accept public welfare ineligible for a green card. San Francisco and other jurisdictions challenged it. The lower courts put it on hold. Then the administration's flipped. Biden would not defend the policy and tried to end it. Goes to the Supreme Court. It's a messy case, right? Again, what happens when administration number one tries to enact policy, then administration two refuses to defend and get rid of it, right? The court basically says, we don't know, they dismissed it, let it go. But if the Republican administration takes over in another 2 years, we have a lot more of these cases where there's this sort of this struggle where you can never do anything because it takes more than 4 years to put a policy into effect. That's when the effect of our current litigation. Okay. February 25th, President Biden nominates Katanji Brown Jackson, who was a federal judge from the District of Columbia, Supreme Court. She was a law clerk of Justice Breyer. I don't think that was a coincidence. I'm sure at least some level they understood that'd be like, okay, Breyer, if you retire, maybe we'll pick your clerk to fill your seat. That's sort of the Kennedy. I think judges are partial to having their clerks replace them. That's apparently a thing. Next case I want to talk about. I should also do the Katanji Brown Jackson hearings. I actually went for not the first day, I was there for the second day of the hearings. These are ugly proceedings. You guys are lucky not to have confirmation hearings. They are awful, awful things. They were attacking her for things I thought were just very unfair on criminal sentencing. How many criminal trial judges were here, formerly criminal trial judges? Okay. Sentencing is one of the hardest things you ever have to do. Is that right? No? Really? Easy? Easy? Oh my goodness, the judge I clerked for said that sentencing was his hardest job. Okay, you guys, do you have mandatory guidelines? What do you have that makes it so easy? All right, well, all right, well, let me take a second. The judge I clerked for, who was a very good judge, said that sentencing was his hardest job. I'll say that. No, he's shaking his head no. Fine. But they were attacking Judge Jackson by saying she was soft on crime. And she gave either low guidelines or below guideline ranges in cases involving child pornography. And I think these are hard cases because very often with the child pornography cases, it's easy to download a lot of pictures in a very short period of time. And people without any backgrounds download 5,000 pictures in a few minutes because the internet, everything just flies on their hard drive. And they're trying to paint her as it's almost like people enabling pedophilia, which was just nonsense. It's politics. I'll just give you just some preview. One of the senators, Republican, won't say who he was blasting Jackson, right? And then his time finished. You know what he was doing? Scrolling on Twitter, looking at people saying good things about him on his phone. I could just see him just smiling. Oh, look at this. He was swiping on Twitter. So it's all for show. And so the job of the nominee is just sit there, sort of smile, not overreact, and sort of not give away what's going on. Okay, but it was clear to me that she was going to, it just was obvious. At this time, also Justice Thomas was in the hospital. Not really sure what the diagnosis was. Some weird unknown infection. Okay, but this reinforces how important health is. All right, I got about 10 minutes left. I'm going to get to the leak, and then we'll break up. Judge Jackson was confirmed on April 7th. Even though Breyer hadn't retired yet. I don't know how this works, how you can have a confirmation and an appointment while there's no actual vacancy. It's one of these weird things they did, but they figured out how to do it. By the way, this is the third Justice Jackson. Everyone knows Robert Jackson, but there's Justice Howell Edmonds Jackson. He was appointed by Benjamin Harrison in 1893. So it's the third Justice Jackson. There's a trivia question for today. I do not have any Florida Turnpike shirts for you to get out, but do they even have people collecting tolls anymore? Isn't it just all electronic? Are there still toll collectors? Is that even a job that exists anymore? I didn't see any coming down here. Anyway, let's talk about April 26th of 2022. The Wall Street Journal had a report on Friday evening, April 26th. And the report seemed to have some inside information, Wall Street Journal. The report said, Roberts is trying to do something, right? Roberts may be trying to pull a justice to his side. It was widely assumed that Chief Justice Roberts would cast some sort of middle opinion where he upholds Roe, but strike down the abortion law. But the journal seemed to say that Roberts was trying to pull Kavanaugh to his side. And I'm like, oh boy, we got a leak. I was the first person who signaled that this Wall Street Journal story was based on a leak. I got excoriated saying, Josh, what are you talking about? There's no leak. Stop being so damn paranoid. People criticize me. The Wall Street Journal doesn't know anything. They did. Right? They got information. Now, I don't think the journal had the leaked opinion. I sincerely believe they did not have it. But they had some information that they were acting on. I can guess who a little later. Right? But they had some information that they were acting on. I wrote about this, and then it sort of quieted down. Then 1 week later, May 2nd, this was the big day, May 2nd, 2022. In the morning at 10 a.m., the court releases Shurtleff versus Boston. This was at the flag case. And the court rules that, again, the Christian group can raise the flag in Boston. That afternoon, the court held a memorial for Justice John Paul Stevens, who had passed away at the age of 99. What a remarkable life. He lived in Florida. I don't remember where he lived. Naples, was it? Where is it? Palm Beach, yeah. Remarkable guy. He was actually at the Babe Ruth game, the Cubs game, where he pulled the home run. Just his parents owned a hotel in Chicago, so he met Amelia Earhart. Just a remarkable human being. Died at the age of 99. And I watched the memorial on C-SPAN, and then they sort of pan to the justices. And they all look very sort of somber and serious. Like, wow, why are they looking, maybe it's a memorial, they're sad for this reason. What we didn't know was they knew the leak report was coming because the press had asked for a comment, which of course the court gave no comment. And shortly after the memorial happened, the court began putting barriers outside the Supreme Court. This is not known. The barriers went up before the leak. They put these, they had them from, January 6th. They had these barriers standing by, I guess, right? But they put these, they call them unscalable fences. You can't climb them because of the way they're constructed. They're very close together. You can't climb them. And for some reason, they decided to put these barriers around the entire perimeter of the court. And that evening, the report came out from Politico. I remember I was walking with my daughters outside, and a friend messaged me saying, "Did you see this?" I'm like, "What?" 5 votes to overrule Roe. And not only did the 5 votes to overrule Roe, there was a 100-page PDF, a draft opinion that the press released. And if you look very carefully at the document, which I did that evening, you see some staple marks in the upper left-hand corner. As so someone ripped out staples. You can see the little holes where the staple was. It's highlighted with yellow, and the highlighting is kind of jagged. This was not a computer, it was actually a physical highlighter. So it looked to me that this was some sort of scan of a physical document. We now know there were about 40 or 45 people who have had access to the document, which is basically the justices, their law clerks, and their staff. The document's not seen outside the chambers. The public affairs doesn't see it. The court maintenance doesn't see it. Draft opinions are put in burn bags after they're done. As soon as this happened, it basically ignited our legal order, right? So the opinion itself was unflinching and unsparing in its decision to overrule Roe. It said in the first page there's no basis in the Constitution. It's egregiously wrong, right? Egregiously wrong. This was a language that Justice Kavanaugh used. It talks about a precedent, talks about stare decisis. Now, what did we not know? The opinion was dated February of 2022. We were already in May. This was about 3 months old. Were there still 5 votes for the opinion of the court? Were there 6? Did the majority lose it? So immediately I started theorizing, what could this be? And there are a couple of possible strategies. So one, let's just call this the conservative league theory, right? A conservative leaked the document to lock in the votes, right? That is, there were 5 votes for a majority. Maybe Justice Kavanaugh was on the fence, flipping back and forth. But once this comes out, it locks him in. Because he'll look like either a coward or a fool for changing his votes after the opinion was released, right? He would have been excoriated for the rest of his life as a coward, right? That's the conservative league theory. There's also the liberal league theory, which can go maybe a couple different ways. One of which is we need to scare the crap out of the public so they can react negatively, get them amped up. And if the public reacts negatively to it, maybe a justice might switch their vote, or this might be an effort to delegitimize the court. Third option is the burn it down option, and I'm going to wrap up with that one, right? Yeah, get you guys on your break in a minute. It's, I don't care if votes go one way or the other, the court needs to be reformed. And we need to start the discussion now to make public attention criticize the court, attack it, and make it vulnerable for the election. We don't know who leaked it. We still don't know. We know what's happened. Justice Roberts ordered an investigation. According to CNN, our good friend Joan Biskupic, phone records were demanded from the clerks. There's no subpoena, so they could have said no, and they have no obligation to provide it. Justice Thomas warned that you're starting to look over your shoulders at the court, that you can't even trust your colleagues. Now, just yesterday, breaking news, Justice Gorsuch made an announcement, which I wasn't expecting. He said, the Chief Justice appointed an internal committee to oversee the investigation. The committee's been busy. I guess he's on it, right? We're looking for the report. So there might be a report. Maybe they'll find it. Maybe they won't. All right, we're right at 10. Let me break here, and we'll be back soon to finish up. I'll tell you everything else you need to know about this term. Yeah, we're going to filter back in. Right, so there were a couple theories, right? So one is the liberal leak. That is, the leak was designed to pressure Kavanaugh to not join the vote to overrule Roe. The conservative leak theory was we need to lock in our votes. And then there's what I call the burn it down theory, where this court is lost, the 5 votes are locked in. Let us just bring negative attention. There's a fourth theory that I throw out there just for the sake of completeness. I was the first one to float it, call me a conspiracy theorist, but it could have been a foreign hack. Don't laugh. In the 2016 campaign, foreign adversaries targeted the Clinton and DNC email systems. Right? They put malware on it. You always get those links like do not click on. We always say do not click in links in email. Right? We always get those alerts. Right? The justices are not tech savvy. If Justice Breyer had clicked on a little link in an email and put malware in his iPad, right? And if you don't believe me, during the Zoom oral arguments, one of the justices, his name begins with Stephen, ends in Breyer, flushed the toilet while the arguments were going on. You could hear it. You could hear a toilet flushing. By the way, if you're an advocate on Zoom and you hear a toilet flushing from a judge, play it cool. Say, what was that? Anyway, so who do I think it is? I'll be honest. I think it's the burn it down theory. The liberal leak theory never made sense. If you put this information out, anything, it would, as they say, harden Pharaoh's heart, right? You make it less likely that a justice flips. And if you're the conservative leak theory, if conservative leak this, you have burned the bridges with your colleagues for the rest of your life. I just don't see it likely. I think it was probably a clerk who's wanted to burn it down and realize this institution is not worth saving anymore. The court and Justice Gorsuch seem to suggest they would actually release who did it. It could have been something as mundane as a custodian, right? An opinion was left around haphazardly on a desk somewhere, right? There are a lot of ways this could have happened. Now I know people are asking, Josh, on Twitter I saw this, Twitter I saw that. The clerks are often told in very clear language that they can't do this. But what's not known is they don't sign anything. Do your clerks actually sign a confidentiality paper? Good. At the U.S. Supreme Court, it's very, they say, gentleman's agreement, right? In the old lingo, where the Chief Justice gives a very stern talking to every clerk saying, do not leak, you'll be fired. But it's not clear they breached any employment terms, right? There's no actual employment contract for them. So I don't know if they could even discipline a clerk. Also, I don't know that there's a crime, actually, a federal offense. These are documents you have access to. And it's not even clear if these are things of value. I mean, they're valuable, sure, but these are things of value where you're stealing government property. So I don't think there's any crime committed. I don't think there's any breach of any sort of employment contract. The court has no consequences. All they can do is just highlight the person's name and bring shame to them. I do hope, though, for a matter of public integrity, they release the results of their conference, their committee findings, because it is a big deal. If this starts happening every year, the court can't operate. I'm sure all of you know. I'm sure opinions are leaked in advance with the intent to modify a judge's votes. Courts can't function. You need confidentiality. I have friends who were clerking last term, and they said the place became a fortress, right? I mean, beyond these physical barriers, chambers couldn't talk to each other the way they usually could. They didn't trust each other, right? They didn't have that sort of a bond rapport to try to keep things settled. Okay? So let's talk some more now about what happened in the wake of the leak. On June 7th, 2002, a person got on a plane from California to Washington, D.C. He had a backpack with him. The backpack was checked. It had a gun, some pepper spray, zip ties, padding for his shoes, and burglary tools. In the days before he made that trip, he had Googled things like, who are the justices of the Supreme Court? Where do they live? How do you assassinate someone quietly? That's why he had the padding for his shoes, so he would make sounds. He went on Reddit. Do you all know what Reddit is? It's like a messaging board site. And he actually posted messages in groups involving Marines asking questions like, I'm writing a book about an assassination. How would you perform one quietly? Yeah, real smooth, dude. Smooth. He published messages in feminist Reddit groups saying, what would happen if one of the justices was murdered? Would that affect the draft outcome in Dobbs? He published, do you guys know what Discord servers are? Do your kids know about this? It's like basically a messaging system. It's complicated, but it's called Discord. He published in Discord asking for advice how to kill people. No one said anything to the authorities. Apparently, no one even cared, right? He literally put in a message board, what would happen if a justice was assassinated? And like no one thought to, I don't know, contact the police? Do we not, we see something, say something, do we not do that anymore? So he flew to DC, took a cab from the airport with his backpack, his goodie bag. He walked up to Brett Kavanaugh's house. Thank God it was surrounded by marshals. If it had not been, he could have entered and murdered the justice and his family who were home sleeping. But he saw the security detail, and I guess he got spooked. And he went a block away. Then he walked back, and he walked away again. Now, the reason why he knew where Brett Kavanaugh's house was because there had been daily protests there by various abortion groups, and they put his address all over the internet. So if you want to know where Kavanaugh lives, you can find it. It's not hard to find. It'll take you 2 seconds. He was in suburban Merrill. He actually lives a few blocks from Chief Justice Roberts' building. They live very close together. Then the would-be assassin calls the police, and he says, "Hi, yeah, I flew here to kill Brett Kavanaugh, but I don't want to do it now. I'm only slightly exaggerating. That's just the call." And he basically turned himself in. Now, putting aside the specifics, criminal law, is there an attempted murder here? This is actually a really hard question. Is there a substantial step? Because it's like a law school hypothetical. If you regret or if you retract yourself before you took it up, is flying there with a gun in your backpack enough? The gun backpack was sealed, right? It was in a locked case. So I don't know if they even got him attempted murder. But I want to put that aside for a second. We came this close to having a justice assassinated over a decision. We talk about judicial independence. When you sort of delegitimize the court as this evil institution, this is the sort of thing that's going to happen, right? Someone will try and kill a justice. This scares me because I have 2 young kids, and I speak often on issues of concern, and you all are in positions of public power. These are horrible, awful days, and this decision got almost no attention in the press. It was actually stunning. If you were on, any news site that day, it was like number 15. Oh well, it wasn't successful, so no big deal. No big deal. No big deal. We got lucky with this one. Next one may not be so lucky. And I somewhat fear that the most we'll get this guy is on weapon charges for bringing the weapon to Maryland without a permit. I don't know that they actually get him an attempted murder. I don't think there's enough of a substantial step. I think he backed out. Maybe a conspiracy charge, but probably not. I think it's going to be hard to get conviction. Maybe people know criminal law better than me can comment later. All right, let's go back to cases. June 21st, Carson versus Macon. I mentioned this case earlier. This was a case concerning the funding of religious schools in Maine. And we had this sort of distinction between status and use, right? Where the government couldn't discriminate on the basis of religious status, but they could deny funding religious use, that is, using the money for prayer and such. The court says, never mind, that you can even fund religious use, just as you can religious status. You can't disqualify a school solely because they are religious. Remember this playing the joints where you can avoid an establishment clause problem, not worry about free exercise? That's gone. The court upended decades of precedent concerning religious school funding. And in this issue, the court's 6 conservatives are solid. There's not any sort of breakage among them. Justice Sotomayor dissented, and she worried where the court was headed next on religious issues. Because, again, the court's conservatives, they fracture on various issues on religion. They are pretty consistent. All right, so now we get to June 22nd of 2022. At this point, the Supreme Court's term looked pretty normal, right? So some free speech rulings, you had some rulings on religious freedom, but nothing earth-shattering. The next week will be the most significant changes in constitutional law in decades, all in the span of about 6 or 7 days. I remember on June 22nd, I spoke to the Arizona State Judicial Conference, which is sort of unique. In Arizona, every judge in the state has to attend. I'm talking traffic court, family court, trial. They're all there. There were 600 judges in the room. I love this small, intimate crowd. It's actually very nice. I feel like I can see all your faces. But I was there saying, well, June 22nd, there are 13 cases left. Let's see what happens next week. Oh boy, what a ride. So the first case to drop was on June 23rd. It was New York State Rifle and Pistol Association versus Bruin, the Second Amendment case. A 6-3 decision by Justice Clarence Thomas. Now, everyone expected that New York would lose, right? They didn't know New York was going to lose. But what did the court do? The court didn't just say, in gun cases, you apply strict scrutiny. right? You review very carefully regulations on guns. The court did something different. Justice Thomas tried to turn originalism into something judges can actually do, right? We often think of academic originalism, this theory in the sky. But Thomas tried to operationalize originalism and make it something that litigants can actually try to explain. And it involves what you might call analogical reasoning. Remember the SATs? Or A is to B, is C is to D. Remember this in the SATs? No, you blocked it out? Me too, right? We reason by analogy. We do it all the time. And what Thomas said is, if you want to justify some sort of gun control regulation, you must show that there was some analogically similar regulation in effect long ago. That is, if this is some novel, newfangled restriction on the right to bear arms, no go. You need to show some sort of historical practice, a tradition, if you will. Right? So it's not even just what does the phrase right to bear arms mean, the original public meaning. It's this text and history and tradition approach where we look to what are the historical analogs. Let's take the right to carry, for example. There's long been restrictions on the right to carry. There was a law called the Statute of Northampton in the 1300s. Yes, even before Queen Elizabeth, we still had English law, right? The Statute of Northampton in the 1300s, which made it a crime to carry in the King's Woods to terrorize, right? New York said, aha, we have a rule that says they can disarm you if you're carrying arms to terrorize people. And the plaintiff said, no, 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 no. This was something very specific, right? Only if you were exhibiting what you might call brandishment, right? You were using your gun to scare people, right? It wasn't enough to just carry a gun, you had to use it for bad purposes. And the court agreed. They said that's not good enough, right? The fact that you might be able to disarm a person if they were terrorizing others does not mean you can disarm law-abiding, peaceful citizens. So the court developed this sort of analogical reasoning, this way of reasoning by analogy. But more importantly, the court upended a decade of precedent, right? Over the last decade, in the wake of Heller, the lower courts have settled on this sort of intermediate scrutiny, which means the government usually wins, and that's what it means. They won almost every case. And they sort of look at history and they wink and they nod, say, okay, well, that's nice, but guns are bad. Thomas is very clear. He says the burden is on the government, right? The burden is not on the citizen to justify his rights. And even if the evidence is sort of in equipoise, is in balance, the presumption goes to, the tie goes to freedom. The tie goes to the right to bear arms. So the court upended the way that lower courts been doing gun control laws for a decade in a minute. You know, like on Westlaw, you put like a red flag on a case. Thomas just threw out like a million red flags at every single lower court opinion on guns. This was a significant shift and really would preview where we're headed the following day, right? So again, on June 23rd, we have the Bruin case where the court uses this historical analogical reasoning. There's still limitations. Justice Kavanaugh wrote a concurrence, as he often does. He likes to write separately, saying, look, I'm not that bad. I'm a nice guy. He does it all. It drives me crazy, right? He's like, oh, look, see, I'm a nice guy. And by the way, I do think his concurrence here was affected by his situation at home. I'll explain why in a minute. He said, all we're talking about here is carry laws, right? Other laws, are fine. The government can still impose different restrictions on who can carry, for example, mental health checks. That wasn't an issue in the case. New York did not require mental health background checks. But Brett Kavanaugh, who'd just been almost assassinated by a person who probably needed a mental health check, put that in his opinion. So look, you guys know this. Judges, their lives affect them. You can't separate yourself 100%. So I think Kavanaugh's saying, okay, maybe the guy who brought a gun to my house should not have had a gun because he was not all there. But Kavanaugh and Roberts joined the opinion in full. So there were 6 solid votes to adopt this strong originalist perspective on the right to bear arms. Justice Breyer wrote a very vigorous dissent. He had dissented in Heller, and he dissented in McDonald. For Justice Breyer, the evidence was not so clear. Breyer said that there is evidence of restrictions in the right to bear arms. For example, in the Wild West, the frontier, very often towns would say you couldn't carry a gun into the saloon and its other town squares. There are some laws saying that if you were a dangerous person, you had to pay a bond to carry a gun, right? The New York law at issue was from the early 1920s, it's 100 years old, right? How are we going to say that a 120-year-old law is not part of a deeply rooted tradition? And Breyer said even if the evidence was at equipoise, right, even if the evidence was sort of balanced, the presumption should go in favor of safety, right? That we should favor the state's ability to safeguard their people. If you remember, there was actually a mass shooting on a subway car in New York City several months ago. That, I'm sure, is looming in the back of their mind. By the way, you know, Justice Breyer was once robbed by a machete. Point. This is a true story. He had a home somewhere in the Caribbean. I can't remember which island it was on. And he actually, a guy with a machete walked into his house and robbed him. Didn't know he was a justice, but anyway. So Breyer had been firsthand witnessing potential violence by machete. Now, I'll sort of give you the aftermath. After this happened, New York, California, other states, they swept into action. New York City has enacted a law that says, okay, we'll give you a carry permit, but you have to do a lot of things. You have to go through background checks. You have to provide references. You have to provide your social media handles. Yeah. So now the government will be scrutinizing their social media handles the last 3 years, see if there's any hateful speech on their social media, which I think is just about everyone probably. So there's still going to be some First Amendment challenges to these gun restrictions. New York has also adopted very broad rules about where you can carry. The perhaps most famous of which is Times Square. Now, we open to Times Square? Right, Times Square is at a 5 or 6 block area where Broadway and 7th intersect, around 42nd to 48th, depending how you count. New York has defined Times Square to be a 36 square block area. Basically, the entire middle of Manhattan is all Times Square. I think it's like from between 2nd and 7th, just it goes all the way out. No, 9th, it goes all the way to 9th, right? That will be challenged. They've banned carrying houses of worship, even if the people in the house of worship want to carry. I even think the stuff at the psychological checks is vulnerable because people might have had some mental health issues many years ago, but doesn't reflect on their current well-being. So there's been a lot of litigation. In the wake of Bruin, there were lawsuits filed across the country challenging various gun control restrictions. We'll see what the court does. Maybe it'll take the court less than 10 years to actually resolve a gun case. We'll see what happens. But Bruin was a huge case in terms of just constitutional law in general. All right, so that was Thursday, June 23rd. My head was spinning, right? I think it was going so quickly. Then we have Friday, June 24th. The court almost never releases an opinion on Friday. Almost never. They just don't do it. They like their weekends, right? Something like that. In recent memory, there have only been 2 opinions or 1 opinion on a Friday. On June 26th, the Friday in 2015, the court decided to Bergefell. This was the gay marriage ruling. Why? Well, June 26th was also the day that Lawrence v. Texas was decided, and Windsor. So you have Lawrence, Windsor, and Bergefell all decided on June 26th. And also Pride Week was in DC that weekend, so it was very well timed. Just think there was some intentionality there. But then on June 24th of 2022, Dobbs drops. About 10 minutes before the opinion came out, I started seeing some texts in my group chat saying they're telling people on Capitol Hill to get out and that there are going to be protests very soon. And the alert's going, okay, everyone stay in your office. So apparently someone tipped off Capitol Police at least 10 minutes before that there was going to be an abortion decision. So I wasn't surprised, but like 10 minutes I was like, oh boy, here it comes. And boom, Dobbs dropped. I downloaded the PDF very quickly because I know the website often crashes. And I read the first page and I thought to myself, wow, this looks really familiar. I've seen this before. And then I'm like, wait a minute, the votes didn't change. Until the last minute, I was convinced something would happen, that the votes would change. I didn't believe it would actually happen because these things always don't go the way conservatives think they're going to go. It's just, it never happens. And then it did. Um, the very first page, Roe v. Wade was egregiously overruled, egregiously wrong was overruled. To a T, it was almost exactly the same thing as the leaked draft opinion. 6 members of the court voted to uphold Mississippi law. Chief Justice Roberts concurred in the judgment. Justice Alito wrote the majority opinion, and he wrote, Roe and Casey must be overruled. The Chief Justice had an unusual opinion. It's very, very strange. Roberts said, we're not going to overrule Roe and Casey. We are going to uphold the law. How do we do this? Well, remember this viability thing? That's not really part of our law, right? Even though Casey mentioned viability like 30 times, Roberts said that's not really part of the opinion. That was basically like dicta. He just kind of ignored it. And he said, if we get rid of viability, this is fine because there's no undue burden on abortion. Why, Roberts says? By the 15-week mark, most women already know they're pregnant. So they've had an opportunity to have an abortion. Therefore, it's fine. There's fair notice. That was Roberts saying, right? Basically, as long as a woman's had a meaningful opportunity to have an abortion, the law survives scrutiny. That's never been the test. And it's not surprising no one joined his opinion because it's incoherent, right? It's just basically, it's Roberts saying, I'm a really smart lawyer. Let me try to make something up to give something to the right and to the left, and no one will even know. I mean, really, that's not what I say, but Roberts' minimalism depends on people being stupid, right? For Roberts' minimalism to work, everyone's just really dumb not to know what's going on. But anyone who's actually read Casey knows what Casey said, and Roberts is not representing it accurately. So I don't buy the Roberts minimalism. It's not persuasive to anyone, and that's why he got one vote. All right, so let's walk through the court's opinion one piece at a time. So first, the court says the Constitution does not even reference abortion at all. Right? Now, that's not the end of the story. There are certain rights that are unenumerated, that is not written down, that can still be protected. These are called unenumerated rights. But what is the relevant test? It's not based on the penumbras in the sky. It's not based on dignity and other concerns like that. It's based on text, history, and tradition. Is this right deeply rooted in text, history, and tradition? Alito says the answer is no. When the 14th Amendment was ratified, the majority of states prohibited abortion. Right? In the 1960s, abortion was a crime almost at every stage of the pregnancy. There's no deeply rooted right. The joint dissent by Justices Sotomayor, Kagan, and Breyer didn't dispute this point, so I don't think they could. But they basically said, who cares about history, right? We should not freeze for all time the original views of those who framed the 14th Amendment. The dissenters wrote, reading the Constitution through a 19th century lens consigns women to second-class citizenship. They wrote, when the 14th Amendment was ratified, women were not part of the people. Male ratifiers, they're all men, were not perfectly attuned to the importance of reproductive rights for women's liberty, which again, no one disputes. So you have this huge gap between the majority saying we need to stick to the 14th Amendment, we need to stick to the framers, what they understood, and the dissenters saying, if we were to do that, we'd be stuck with a 19th century approach to equality, which we do not have in other contexts. So there was a huge fundamental ideological and philosophical divide between the majority and dissent. There's also that little thing called precedent. For the last, half century or so, the courts decided many cases not based on history and text. Most recently, Obergefell v. Hodges, same-sex marriage. Lawrence v. Texas, right to sexual relations. Griswold v. Connecticut, a right to contraception. Loving against Virginia, right of interracial marriage, right? These are all cases that were decided based on substantive due process, not based on history and tradition. Does Dobbs put those precedents in jeopardy? Majority said, no, don't worry about it. I promise, pretty please, sugar on top, right? Majority said, we are not casting doubt at any of those cases. But Justice Thomas said, oh, by the way, there's always the oh, by the way with Justice Thomas. Yeah, Obergefell, Lawrence, Griswold, yeah, we should have ruled those also when we get the chance. So he can't help it, right? This is who he is. Justice Thomas firmly believes in his cause, and he felt the need to say it in this case, in all cases. So I don't know if you believe the majority or not, but at least the court said, we're not going to do it. I think that sort of locks them in. It would look very disingenuous if they sort of change their minds. Also, as a practical matter, gay marriage has been accepted in ways abortion simply hasn't. There's no march in Washington to overrule gay marriage. There are gay couples all over the place. People know them, they're friends with them. And the idea of removing licenses from millions of Americans just seems unfathomable. So I think there's some posturing going on, but the Thomas implication, I think, does handedly follow through with what the majority said. The second part of Dobbs focuses on precedent, stare decisis, this concept. And Alito wrote that some of the court's most important decisions overruled precedent. So Brown's Board of Education repudiated Plessy versus Ferguson, separate but equal. By the way, it didn't. If you actually read Brown, which it's very short, you can read it, it says, Plessy has no place in the context of public education. It was limited to public education, and really Plessy was about trains. So it didn't actually overrule Plessy altogether. It was sort of just kind of said, we're not going to follow this anymore. West Virginia Board of Education versus Barnett overruled Minersville School District versus Go Biden. This is about requiring students to salute the flag. By the way, we salute the flag like this now. Back then, it was like this. It was actually kind of like a Nazi salute. That's what kind of looked like, see the pictures. But that fell out of favor in the 1950s. West Coast Hotel v. Parish. That's true. Overruled Atkins versus Children's Hospital. And in this case, signaled the demise of the Lockyer line of precedents. Obergefell, gay marriage, overruled Baker versus Nelson. Lawrence v. Texas, sodomy, overruled Barrows v. Hardwick, and there are many similar cases. And the court identified 5 factors of when you overrule a case: the nature of their error, the quality of their reasoning, the workability of the rule, their disruptive effect on other areas of the law, and the absence of concrete reliance. They walk through those 5 factors. Roe was egregiously wrong and deeply damaging. It short-circuited the democratic process by closing to the large number of Americans who dissented from Roe. Second, Roe was based on erroneous historical narrative, right? Even if abortions were permitted early on before the so-called quickening phase, the fact that some things were allowed does not make that a constitutional right. Let's say that point again. The fact that some types of abortion were allowed does not mean the state lacks the power to ban those, right? A right is something that's discussed openly. People say that's a right. You can't just infer rights from the failure to criminalize something. Third, he said the court has struggled to follow Casey. Circuit splits have formed, right? One circuit interpreted Casey one way, the other circuit the other way. Roe and Casey distorted free speech jurisprudence, federal courts jurisprudence, and freedom of religion jurisprudence. But the last part is most significant, which is reliance. If you read the Casey plurality, O'Connor, Kennedy, and Souter said that women have come to rely on Roe, that women in the economy make their decisions based on knowing that Roe is available as a backstop if they need it. Alito says that's wrong, right? Reliance is not based on people organizing their intimate relationships. He says it's something different. Reliance is based on things like property and contract rights. He completely undermined the basis of Casey in a few sentences. Justice Kagan, who was very active on this issue during arguments, said that since Roe, women have based their lives on knowing this right exists. The arguments today are different than they were 50 years ago. Alito responded, the court is not equipped, though, to assess generalized assertions about the nation's psyche. So he rejects that altogether. The next part of the court's opinion concerns legitimacy. Now, people use this word all the time. They never stop to think what it actually means. Legitimacy. What does it actually mean? I submit the term's kind of meaningless. It just means something you like or not. Like, legitimacy is good. Who doesn't like, everyone likes legitimacy. But the cost, though, is how a court's supposed to assess their own legitimacy. In Casey, the plurality worried about overruling Roe. Let me just read you one sentence. This is from Justice Souter, Penn. To overrule under fire in the absence of the most compelling reason, to examine a watershed decision would subvert the court's legitimacy beyond any serious question. Okay? During oral argument, Justice Breyer worried that when you have a super case like this, Roe, people say, no, you're just being politicians. Justice Sotomayor was more blunt. She said the reason why Mississippi enacted this law was because of the new Supreme Court justices, the conservatives. And she said, I can't do justice, but she said this in court, will this institution survive the stench that this creates in public perception, that the Constitution and its readings are just political acts? How will we survive? Table that if the leak came from her chambers. Just come back to that one later. What happened? How will we survive? The Dobbs majority basically said, we don't care. We don't care. The majority said Casey was wrong when it treated a national controversy over abortion as a grounds for refusing to reconsider that decision. The majority said that Casey was wrong to consider legitimacy in this fashion. Courts cannot allow its decisions to be affected by any extraneous influence, such as concerns about public reaction. In other words, we don't care. We don't care what will happen. And again, this was written after there was an assassination attempt on the justice. This was written after a commission was formed to reform the Supreme Court. Right? This was written after politicians all across the board saying we need to pack the court. And the majority said, we don't care. We do our job, you do your job, leave us alone. This is such a reversal from the Casey court, right? I mentioned earlier, the decision about appointing judges was to basically correct the error that led to Casey. I think we saw this with appointments at all levels in the last 4 or 5 years. The final element of the case concerned the standard of review. The court says abortion laws will be reviewed with rational basis scrutiny. So meanwhile, the gun stuff is basically like this super strict scrutiny. The abortion stuff will now be a rational basis standard. Abortion was not considered a fundamental right. The Mississippi 15-week ban passes that test. The state had an interest in protecting the life of the unborn. It didn't matter if the fetus was viable at that point. So the 15-week ban easily passed constitutional muster. Unclear if a 6-week ban would as well, because many people don't even know they're pregnant at 6 weeks, but that was not an issue in the court. Again, Justice Thomas wrote a solo concurring opinion. Thomas restated his view that there is no substantive due process, and we should overrule Lawrence, and overrule Obergefell, and overrule Griswold, get rid of all those cases. Majority said, no, Thomas, stop screwing things up. We're not going to do that. But the Thomas opinion was out there, and it's giving a lot of juice to critics of the court. Justice Kavanaugh wrote a concurring opinion to tell him he's not really a bad guy. We decided all these issues that were before the court. He said that a state cannot bar its residents from traveling to other states to obtain an abortion. I don't know, wasn't briefed, wasn't before the court, but he decided it. He said, I'm deciding because I'm Brett Kavanaugh. It's actually a really hard question about the right to travel. This idea of a right to travel is sort of nebulous in the Constitution. And even if a person can go to another state and come back, can you punish people who fund that travel? Can they exercise that constitutional right? This may come before your courts. I won't say anything more about it, but it's a very hard issue. I think Brett Kavanaugh gave it like the whew, just back of his hand treatment. Kavanaugh also said that you can't retroactively punish someone for an abortion that occurred before Dobbs. I haven't seen any evidence that will happen, but also I think it's a hard question. Retroactivity for criminal law is not so straightforward. Again, these laws have been in the books for 100 years, so there's not really retroactivity. Again, the Chief Justice concurred in the judgment, and he said, well, the test I would pick is, did a woman have a reasonable opportunity to have an abortion? If the answer is yes, it passes muster. Again, that was never the test under Roe and Casey. He just made up a new standard. Why? I don't know. I mean, I know why he did. He didn't want to be seen as overruling Roe, but he wanted to get rid of Roe. So I'll just pretend, like kids like make believe, right? Just pretend viability was never the standard, and no one will know. There's no spoon, right? In the end, the majority ruled Roe and Casey. They said we're returning this authority to the people and their elected representatives. The court wrote, we do not pretend to know how our political system or society will respond to today's decisions overruling Roe and Casey. Right? They said, we don't know what's going to happen. I have no idea either. I think we're already seeing the democracy work. There was a vote in Iowa about amending the Constitution. Kansas about amending the Constitution to eliminate a Supreme Court decision about abortion. It lost. Michigan will have a vote as well about abortion. There'll be referendums across the country. Say what you will about the opinion, but democracy is working its way pure. Even in conservative states like South Carolina was trying to pass a complete ban, they didn't have the votes. And they actually, I'm paraphrasing, they said, it's a lot harder to legislate without a Supreme Court decision in the background, because you actually have to make tough decisions on your own. For generations, Republican members could just pass whatever the hell bill they want, say, Supreme Court will let us enforce it. But now there's accountability. So I think at some level, Justice Breyer will appreciate that the Dobbs decision did restore democracy to 50 states. Well, if he admits it or not, I don't know. All right, so let's go back to our chronology. That was June 24th. Again, that was a Friday. The opinion was like 200 pages long. I read the entire thing. It took me a weekend, but I read all of it. Now I was on top of the gun case. So I was busy. Then we get to June 27th, and we have the case of Coach Kennedy. Kennedy versus Bremerton School District. He was a high school football coach. Actually, he was an assistant coach. I don't make a point, but he was the assistant coach. He was not the head coach. And he had a practice of kneeling. Tim Tebow, right? He would kneel at the 50-yard line after games to say a silent prayer. All right? He's in Washington, outside of Seattle. And the school district determined that having the coach pray by himself, kneeling at the 50-yard line, would violate the so-called Lemon test. Remember the Lemon test? Lemon versus Kurtzman was a case from the 1970s. It was an Establishment Clause case, which said if there is some sort of intermingling between the church and state, the violation of Establishment Clause. If the government has the purpose of advancing religion, it's unconstitutional. This test is weighted in favor of finding Establishment Clause violations and was used for decades to stop all manner of religion in the public square. Now, the Coach Kennedy case, though, wasn't about the Establishment Clause. He was fired from his job for praying at the 50-yard line by himself. Students would assemble him, but he wasn't calling them over. It was sort of this thing where he would pray and people just sort of flocked to him. That's how I suppose it goes. The court ruled for him, and the court ruled that the prayer that he was saying was actually protected speech. Right? It was protected speech. All right? But the court had an aside, as they often do. The court had an aside. And what the court said was that the lemon test was abandoned. Huh? We had just overruled Roe a couple days earlier, and now we've ruled the lemon test. But they didn't do it directly. The court said it's already been abandoned. When? I don't know. It never happened. Right? Again, so this is Justice Gorsuch, who again pretends things happened, didn't really happen. It's just, I swear, again, the Supreme Court's decisions rely on people being dumb. I don't want to say that too candidly, but if you actually read things carefully and you know what you're talking about, that never happened. What are you talking about? That's nonsense, right? So let me walk you through what happened. A couple years earlier, we had a case involving a public cross. It was a World War I memorial in the shape of a Latin cross. It was like 50 feet tall. It was huge in Maryland. And a group challenges saying it violates the Establishment Clause. All right. The court said the cross is fine. The cross is fine, but they didn't overrule the lemon test. They just kind of didn't use it. Now, Gorsuch says in the Kennedy case, see, we already abandoned it in the Maryland case, even though they didn't. So it's like this weird, bizarro world where they say things happen that never happen. Again, this term, overrule Roe v. Wade, expand the Second Amendment, and get rid of the lemon test. Plus, with the Maine school choice case, we expand free exercise. There's significant doctrinal changes to the law this term. All right, then we get to West Virginia versus EPA. This is a case about climate change. And the facts are painfully complicated. The facts go back to the Obama years, right? The Obama administration and now the Biden administration tried to enact plans to shift how energy is produced from carbon, coal, to various clean sources. In the middle, the Trump administration tried to undo that and to stop this shift. But the question in this case was a little bit more simple. Does the Clean Air Act allow the government to sort of create this called a generational shift from carbon to clean? And the court said, no, it does not. And this case invokes what's often called the major question doctrine, which goes something like this. If there's some really important question, we want a clear statement of congressional authority, right? We won't read generic statutes, definitional provisions, interstitial matters, if you will. We want a clear statement that something is lawful. This major question doctrine can be used to undermine almost all administrative policies because Congress doesn't legislate anymore, right? There's a big problem. Congress does nothing. And the executive branch says, aha, we will take the Clean Air Act of 1972, signed by Richard Nixon, to regulate climate change. Right? We will take the Occupational Safety and Health Act to mandate vaccines. Right? We will take public quarantine laws as a way to mandate during COVID no evictions. Right? They reach back to these old statutes and say, aha, we found this new power. Let's go to the signaling. No way. You can't do that. It's not clear where the lower courts go on the major question doctrines. All right. Whew, okay. That was the end of last term. I could do 5 hours in just last term. Seriously, the amount of doctrine last year was stunning. Let me just give some statistics. People like numbers, maybe they don't. The court decided 60 cases last term. That is one of the lowest numbers since the Civil War, right? The court is just not deciding many cases. And they're deciding even more cases that are unargued. 14 involved a 6-3 partisan split. 10 of them were 5-4 partisan splits. All of these, the liberal justices stuck together. So they always voted as a block. 40% of the cases were ideological on school choice, religion, guns, and vaccines. Only 25% of the cases were unanimous, 9-0. Usually it's more like 30 to 40%, so there was less unanimity this term. Which justices agreed the most? Roberts and Kavanaugh, the neighbors, agreed 86% of the time. Breyer and Kagan agreed 79% of the time. Sotomayor and Thomas agreed 30% of the time. They were the most opposite end of the spectrum. Now, In all the 5-4 splits where the liberals were in the minority, Justice Gorsuch joined the liberals. So Gorsuch was a judge most likely to join the court's three progressives. Again, he's idiosyncratic. He doesn't really fit any mold. I think what this shows is having a margin of error is very important. Even with 5 conservatives, they don't always vote as a block. So I guess you need 6, and that's what it took to overrule Roe. Let me look. I got about 10 minutes left. I do want to have some time for Q&A. Let me look forward to next year, and I'll maybe mention some of these a little more briefly than I would otherwise. Next year is going to be big, not huge, but big. Probably the most significant case involves election law, which this state knows nothing about, I'm sure, right? Sorry, I keep talking. I try to make it local area. Hello, Cleveland, right, wherever you happen to be. Graham's waving signs at me. I know. So one area of case law involves the independent state legislature doctrine. If you don't know what this is, get up to speed. It's going to matter very soon. The Constitution, right? Wrong pocket. Sorry. It's my bag, right? The Constitution provides that the state legislatures can set voting laws. State legislature. Does that mean state courts? So in Bush v. Gore, Chief Justice Rehnquist wrote a concurrence where he called out a certain state court I shall not name and said, it's not clear that this state court can even set voting rules because the Constitution gives the state legislature the power to set these rules, and the state Supreme Court in question stepped out of line by trying to create election law on the fly. Now, that was a concurrence. It was not the majority. But was that?
Yes.
The answer is yes.
I agree. Step that one.
Okay. I promise I play nicely. But the court case was only a concurrence. But in the wake of the Bush v. Gore decision, scholarship was developed saying, wait a minute, how are these state courts making rules regarding districting? Right? How is this possible? And so there are various strands of independent state legislature theory that says that only the legislature can do it. Now, of course, legislatures enact statutes, and they authorize courts to review their actions. Right? There are most state constitutions that's at least implicit or expressed. Also, many state constitutions have laws governing voting. I'm assuming yours does as well. So what role is there for the courts? So North Carolina, their Supreme Court has been in the news recently. They're pretty active. And they basically told the legislature, no, you can't enact these maps because they're partisan gerrymanders. Not necessarily racial gerrymanders, but partisan gerrymanders. The legislature said, no, that's our job, and you can't even review it. So what happens next can be a range of options, right? The most aggressive would be the court saying that only the legislature and not the state courts have any role in this, which would give the elected members complete plenary power over their own maps that they're used to protect their incumbency, which is how map drawing has always worked since the days of Elbridge Gerry in Massachusetts in the 1800s. That's actually the word gerrymander comes from Elbridge Gerry. He was the governor of Massachusetts, and they drew a map that looked like a salamander. They called it gerrymander. That's the origin of the term. Other more mild versions are if a state court wants to sort of exercise this power, there must be a clear statement in the Constitution, right? In North Carolina, there's like the Constitution says we shall have elections that are fair, and that's sort of this very nebulous provision, right? The other biggie coming up this term is affirmative action. Last year, Roe was overruled. I suspect this year, Grutter and Gratz might be overruled. And I think the court might say that we're not going to allow this sort of race-conscious admission where diversity is used to sort of so strongly outweigh the admissions process. The one case involves Harvard University, the allegations that Asian American students are being discriminated against. The other case involves UNC and University of North Carolina as well. We have Sackett versus EPA with waters of the United States. What if you have a lake over here, houses, a paved road, an empty lot, and then some wetlands over here? Can the empty lot be regulated that's separated from the lake by a paved road and a bunch of houses? And the government says yes, and the private owners say no. We have 303 creative versus Elenis, E-L-E-N-I-S. This involves, can a graphic designer be forced to make a website for same-sex marriage, right? This issue has been percolating, it seems like forever. We might actually get some clarity on whether there's a free speech right not to be forced to create a website for a same-sex wedding. All right, I'm done. We have 5 minutes left. Happy to take some questions, but thank you so much for your attention for the last 2 hours and change. Thank you.